Welcome everyone. This is week number 8 of the Ibis Prep Florida Bar Crash Course. And we just had a guest in the class, Jesse, who practices family law. And we also discussed that as of July 1st, 2023, they have made some important changes to family law. And we were able to go through the new legislation and deduce that instead of 7 to 17 years for a moderate marriage, it's now 10 to 20. And now there is no such thing as permanent alimony in Florida. And finally, in Florida, it doesn't need to be unforeseen or unforeseeable change in circumstance. It just needs to be substantial and material. If everyone out there can know that as of July 1st, 2023, those are the important changes and enactments, you will be light years ahead of all other students because they're not teaching this in other courses. So with that background, I'm going to continue doing my lecture, but we did discuss how as of July 1st, 2023, there is some new legislation that is potentially impactful. And to be sure, Florida does have the ability to test anything as of the day the exam is administered. Do I think they will? Absolutely not. I think that would be cruel and unusual, violation of the 8th Amendment potentially, but I don't think that it's something that is not good to know, right? The more you know. So that's how I'm going to start class, by talking about the new legislation, and then we're going to ease right into something that should be fun, our brand new album, Pillow Talk, the album. And you can see Sanctity Beyond Bond, Not Even Past Death, Third Party Problems, and Me Versus You. So I guess these are the singles from the album. Does the creator of this album want to talk about it at all?
I mean, not really. It's kind of embarrassing now, but I had a lot of fun making it.
Oh, I didn't even see this. Privilege Records, the Ibis Labels Production Studios. It's very awesome. So we understand what she means by this, right? This is talking about in Florida, there is a privilege between married couples where what is said in the sanctity of their marriage is protected and they don't have to testify about it. However, we must distinguish that in Florida, there is no testimonial marital privilege. So whereas in the federal, under federal law, you can refuse to testify against your spouse, that privilege does not exist in Florida. The only privilege that does exist is this so beautifully named Pillow Talk rule, which is about confidential communications. We talked about JMOL versus renewed JMOL. This is an MBE one. Does anyone know what we call this in Florida?
Motion for a directed verdict.
And what would be the second one?
Renewed motion for a directed verdict.
I don't think I'm going to accept that. Does anyone know what it's truly called?
Belated.
Belated, yeah. And I'm just sticky and picky with the words because this is the test. Yeah, we call it a belated motion for a directed verdict. Okay. And then we had the exclusive squatter, adverse possession. This was also someone taking federal. And then you all remember my album about quasi-contracts, quantum merit, ill-gotten gains, unjust enrichment, restitution. Remember, those are all those concepts of ways that we can have a remedy in some sort of court-imposed way under contract law. All right, sweet. We got some good feedback. I love that. Let's go right into family law, but just real quick, I want to go over the calendar because, as everyone knows, the test is literally 3 days from yesterday, right? And I can relate because I'm taking the UBE and I'm going to be sitting in there doing the same thing. So we've made it to the month of July. We're doing family law today. I have the essays. I'll show you what essays I've assigned to write. And then on Saturday, we're going to do probably the most thorough workshop of the year. It might extend longer because I want to do Article 3, Article 9. I might even try and do the trust questions in there. I might even look at some family law essays in there. I might even look at some ethics essays in there too. I might look at 5 different subjects on Saturday. Saturday's gonna be jam-packed of information. Please try to attend on Saturday because we missed Monday. So then next week we'll do trust and ethics, just substantive reviews like lectures. And then the following Saturday, a proctored exam. So we've created an exam for you that's part essay, part multiple choice questions, and that'll just be a good way to, see where, feel good. We're not gonna scare anyone. We're just gonna give everyone a little bit of a taste, right? And then the week before, this is my Florida course. All my other courses end this week, but Florida, I really care about my students. I don't want to leave them with just like, all right, see you later. I want to do a week of final review. So it is the week before the exam. We're going to do review on Monday, Wednesday, and on Saturday. My goal is to leave no stone unturned. Ask me literally anything, go over every single subject, make sure that we feel super, super confident. But I can't stress enough that everyone needs to be accountable on their own, to be taking this like a full-time job, to be studying militantly. July is the month I don't really mess around. We don't do discounts on our tutoring. We don't do these like last minute, I'm freaking out things. Like if you're freaking out now, reach out to us and let's get something scheduled. We're not gonna deal with like last second catastrophes. We want people who are soldiers, who are ready for war come test day. All right. So let's talk about last piece of administrative, the weekly assignments. So the week 8 assignments are the 2 family law essays. And then I really want everyone to start tackling all the Ibis multiple choice questions that we created. We created questions for Article 3, Article 9, trusts, and criminal procedure, civil procedure, evidence. There's multiple choice questions. There's 400. I've said it on my honor. If you can memorize, like I have, it's not that hard and not that long of questions, all 400 answers to all 400 of those questions, you will dominate the Florida multiple choice question. I've made those questions specifically molded for what I anticipate to be tested. I'll take the fall if they don't work. I really believe those questions are solid. And then, read and recite all questionnaires once a day, right? Every essay subject, you should be reciting those questionnaires like they're poetry. Like you should know what I'm going to teach you today. It's called MJV Peace, right? Like, MJV Peace, like modification, jurisdiction, venue, parental rights, these different issues. I'll teach you the acronym today. I think the E is for, I forget.
Equitable distribution.
Oh, sorry. E is for equitable distribution. Thank you. E is for equitable distribution. A is for alimony. C is for child support. E is for everything else, or esquire fees. And then D is for dissolution. So we'll go over, all the ways of approaching a family law essay. And I have 2 of the most amazing family law PowerPoints that are created by 2 of my professors who are awesome at family law, and we'll go over them. So don't worry, I'm going to give you guys a great questionnaire, and you'll just remember how to address all those issues, modification, jurisdiction, venue, parental issues, equitable distribution, alimony, child support, everything else, esquire fees, and then dissolution. So we'll go over all those things and we'll feel really, really confident in it. By the same token, you should be able to go through the questionnaires for every single one of my every single one of the subjects tested, and just what is a contract, UCC versus common law, what are goods, and just go all the way through and be able to recite them. That approach is bulletproof. If you can recite all my questionnaires and all 400 answers to the multiple choice questions, you'll pass this test. I also want you to continue writing practice essays, because the one thing that could throw a snare in that plan is if on test day you run out of time and you're not aware of circumstances and situations. You have 3 hours to write 3 essays, and if you only write 2.5 essays in those 3 hours, you're not going to pass. So the only way to kind of assure that you're going to do that successfully is to write practice essays. So I've assigned you these 2 essays. They're very, very recent, both from 2021. In fact, they're the exact same link because they're on the same, July, February. So that's that. We're moving down the final stretch, but remember, don't forget about those important subjects of contracts, real property, con law, torts, civ pro, crim pro, evidence. Those are the ones that are most heavily tested. Those are the things you should really, really be strong with. And then we'll tie it all together with ethics, because remember, ethics is always, always tested. All right, cool. So that's kind of the assignments. And now we can go into the materials folder and look at family law. So you can see the course is really filling up with fun activities. It's getting hot in here. And let's begin. I think there's 2 really, really good PowerPoints that I want to work off of. I don't know which one I love more. But actually, I think I love the other one more. No offense to the creators, but this one is cuter in my opinion. See, very cute. So can everyone see the PowerPoint? If I show the slideshow, I don't think you can see unless I do it like this. How about now? And thank you all so much for your patience today. I just thought it was important to uncover the newly enacted legislation. And I also thought it was valuable to have Jesse kind of share his thoughts about the practice of family law. So as we can see, this was created by Will. Will is my man, one of my best tutors, and he was a former student of mine. You know how it goes. Okay, so MJV Peace, modification, jurisdiction, venue, parenting plan, equidistribution, alimony, child support, everything else, which is attorney's fees, which I told him should be Esquire fees because it would make more sense to me, but I'm just so critical. And then dissolution. So MJV Peace, I love this acronym. Why? Because it's easy to memorize and it makes you know all the things you need to talk about. Jeremy, who created this acronym, actually made it JV Peace with a side of mustard. I have no idea why, but I think it's because modification typically does come, you know, towards the end of the thought process. However you want to arrive at it, these are the important letters and they mean these important things: modification, jurisdiction, venue, parenting plan, equidistribution, alimony, child support, everything else, dissolution. These are not hard things. We're going to remember a few rules and I'll go over them. I have a rule sheet and you'll be able to crush these essays. That's why I was able to spend a lot of time at the beginning of class, because I do believe family law is a very easy essay subject if you just know a few strong rules. All right. So modification. Parenting plans are generally modifiable, but child growing up and a known drug user continuing to use drugs are not unanticipated. Now, as of July 1st, 2023, it doesn't even matter if it's unanticipated or not. As Jesse said, a kid becoming diagnosed with ADD, it doesn't matter if it's unanticipated or not. It just has to be a substantial material change in circumstances will be a reason to petition to the court for a modification, whereas equidistribution is not modifiable. So alimony and child support, things that would, give cause to modification, alimony and child support, changes in financial ability, change the need of the parties and the child, a $50 or 15% difference between the past award and the child support guidelines, and availability of medical insurance, and the retirement of a party, alimony only. So we just kind of talked about this with Jesse earlier, that there's going to be factors that the court would consider in whether they would award a petition for a modification. And these are some of the factors they would consider: changes in financial ability, changes in the needs of the party, medical issues, or, if their job was different or not. But as I asked Jesse, I said, hey, what if I'm married, we get divorced, we have kids, whatever, 20 years later, I'm like, you know what, Janet, I always wanted to be a guitar player for the Jimi Hendrix cover band, and then I'm going to go do that instead and make $5 a month. And now I can't pay. Jesse was like, no, the court is going to say that is a voluntary departure from your, guidelines, and that's not going to be cool. So these are just some thoughts. Modification, we want to really think about a substantial material change that would justify petitioning to the court for them to award a modification. And we'll go over all these things, so don't worry. Jurisdiction, very, very important. This is probably where I would start. That's why I think Jeremy did it JV Peace with a side of mustard, because it does kind of make sense to talk about modification after the parenting agreement is created, right? But that's just a concept to know that, like, modification will be a substantial, a material change and they petition to the court. I would probably begin my essay talking about the jurisdiction, right? So you need personal jurisdiction and subject matter jurisdiction, just like any type of case. Personal jurisdiction is where there's consent, where they're personally served or domiciled, or minimum contacts, right? Like that's just normal personal jurisdiction. Usually it's going to be where the, marriage occurred or where they lived when they were married. There's a lot of ways to have personal jurisdiction over the parties. If the question says that jurisdiction is proper, would you still write a paragraph or so about jurisdiction? Me, absolutely. I would say this question, the facts state that jurisdiction is proper, which means that they had personal jurisdiction, subject matter jurisdiction, and the like. I'm a master of that, right? I take no facts for granted. but I also am very cognizant of my time. Like even when I'm teaching these classes, like today I'm like, okay, maybe we'll go to 8:30 or something, but I'm always super cognizant of my time because we live in a very like time crunch society. You know, that's why I'm always telling people when to start bar prep, what they need to do, how many questions they need to do. Like I'm very much like compartmentalized. I have 2 minutes to write about this thing is what I would say to myself. I'll be like, okay, Andrew, I see that they gave me a fact that's assumed. I'm not going to get many points at it. I might get 0 points on it. So 2 minutes to just discuss it and move forward. I'm literally speaking directly to you when I say write more practice essays to really get a grip on how you're going to perform on test day. And remember, especially if you're a first-time test taker, time is going to move quicker on test day. You know, your stomach is going to turn, everything's just, you know, so like, I'm just letting you know that. Try to write essays a little bit quicker than you're going to need to on test day to allow yourself that understanding that maybe, you know, situationally, you might not be as quick to think and to write. There might be some nerves. Everyone is going to have nerves. Okay. So personal jurisdiction, subject matter jurisdiction, generally just, you know, family court, residency requirement change, required to be a resident of Florida for at least 6 months before dissolution. And don't worry, I have another thing we're going to go through that gets a little bit more into detail here. I think this is just the general understanding that you do need personal jurisdiction of the parties, and you're going to need subject matter jurisdiction, and it would generally just be a family court. And the resident requirement is where either one of the spouses or the children or whoever, you know, whoever's at issue here was a resident of Florida for at least 6 months before the dissolution. So here it's talking about divorce. So it'd be the spouses, you know, they're resident for Florida. Here's something to definitely know. If you're stuck on a jurisdictional issue and it's between Georgia and Florida, Florida is going to have jurisdiction because this is the Florida bar exam, right? Like, do not just write an essay and be like, oh, Georgia would have proper jurisdiction, therefore the essay will not continue, right? Like, try to continue writing the essay. If you get stuck in a wall, you know, try to write the way that'll allow you to continue. I believe that Florida is more likely to have jurisdiction. Yeah, Florida. All right. The UCCJA applies to children. You're lucky. When I was taking this test in 2017, we also got tested on dependency. So you can be grateful that you don't have to be tested on a pretty difficult subject. The UCCJA applies to children. They must have been a resident of Florida for 6 months or born there. If they haven't been in the state for 6 months, it reverts back to the last state where they were. So first thing we learned, right, when it comes to jurisdiction, there's a 6-month rule, right? Get that down. It's 6 months where, you know, the child lived or where either the spouse lived. That's going to be important for jurisdiction. Everything else is pretty much obvious, but if you could just remember, the 6-month rule. Okay. So pop quiz. Ooh, I like this. Pop quiz, hot shot. Amy and Bob get divorced after a 5-year marriage. Amy is in the military, so they've moved all over. From January, February of 2022, they lived in Georgia. From February to May 2022, they lived in Virginia. From May to the day they got divorced, December 22, they lived in Florida. Okay. They had a child together in May of 2022 while living in VA. Where's PJ? Where's SMJ? Where does the UCCJ apply for the kid? Okay. Anyone have any thoughts here? For the last 6 months, they've lived in Florida, right? It's kind of what I was saying. Yeah, Florida. I mean, Florida seems like the obvious answer here, but what about the kid? Where did the kid live? They had a child living in Virginia, and that was May of 2022. But it's kind of ambiguous, right? Whether the kid lived in Florida or Virginia. I mean, the kid was born in Virginia, but where was he living from?
It says they lived in Florida.
Yeah, so I mean, whatever. This is a question written by Will. I can't ask him what he was thinking here, but just generally assume I'm telling you on the exam, Florida is going to be the proper jurisdiction. Okay. Venue is proper where the breach occurred. It's kind of hilarious when you think about what a breach would be in terms of a divorce. The marriage last existed or one of the spouse lives. Very easy, right? That's where venue would be. Venue remembers the location. Subject matter jurisdiction is what level of court, and personal jurisdiction is the power of the court over the person. Big thing here is the 6 months. If you can just remember the 6-month thing, you can pretty much get away with just understanding civil procedure and writing about jurisdiction. But remember, you have to discuss. The first issue is whether this court would have jurisdiction over the modification of the final judgment agreement or whatever they're talking about. Okay. So yeah, I think the infant was probably living with the parents. That would make a lot of sense. Just a real quick aside, this is a story no one will believe, but my grandparents were both born in Miami in 1928. But my grandfather was actually born in Virginia, Richmond, Virginia, because his mother's mother said at the time that Miami was like an uncouth swampland and she didn't want her grandson to be born there. So she demanded that my pregnant great-grandmother drove from Miami to Virginia to have the baby and then drove back down to Miami 6 months just so that he could be born in Virginia. So my grandfather lived in Miami for 92 years, but he was technically born in Richmond, Virginia. My grandmother lived her whole life here. All right, let's talk about parenting. So parenting is about time sharing. So we talked about the mnemonic was JV Peace or MJV Peace. The M was for modification. The J was for jurisdiction. The modification had to be a substantial material change in circumstance, and the jurisdiction is pretty much regular civil procedure jurisdiction. We just got to remember this 6-month rule. And we're gonna get a 50-mile radius later, but right now we'll just do the 6-month rule. So I'm sorry. We are at how did my screen just do this? Parenting plan. Time sharing, not custody. That's a point that Jeremy, one of my instructors who practice family law, said. They don't like to use the word custody in practice anymore, but on the bar exam and the model answers, they use it all the time. So I'm kind of on the fence whether I would use the word time sharing or custody. He was big on not using the word custody, but then the model answers use the word custody. So I don't think it's that important on the test, but just know that this is talking about parenting and, if there's a divorce, how are we going to split up the kids? Well, we're going to have a parenting plan, right? And the parenting plan is going to discuss how we're going to parent the children, and it's going to be regulated by whatever's in the best interest of the child. If you write a family law essay, you better write that phrase 3 to 4 times, the best interest of the child. That is always going to dictate how things should operate in family law. And Jesse was saying that before class in practice. So the decision-making authority, Will loves mnemonics, sus, so shared. The court is the tiebreaker. That just means like they're going to have shared decision-making, they have to come to an agreement. Ultimate, one party gets say over a specific topic or topics because there's a basic disagreement. And then sole, one party's in danger to the child. So ultimate is what I was talking about, where it's like Andrew has decision-making over sports and Brittany has decision-making over school, right? Because she's a teacher and I'm a super athlete, right? Like that would be a ultimate. I also have heard that called parallel. You can use that term as well, parallel. Shared is going to be like, we're going to try and do this together. But just know that Florida, you do have a constitutional right to raise your child. They cannot take the child from you. If you have a case, on the bar exam and they're trying to take the child from one of the parents, just know it's really hard to do that in Florida, unless the parent is really a danger to the child. Like he's on drugs and he's, abusing the child or something. We tend to believe that it's beneficial for a parent to have influence by both parents. All right. Amy and Bob get divorced after a 5-year marriage. They have 2 kids together, C and D. Amy has spent much of her time caring for the children while B has showed little interest in them. After divorcing, however, Bob indicates he wants primary control over the children. Amy has a small 1-bedroom apartment while Bob has a 3-bedroom one. Bob works 90 hours a week and Amy works from home. What should a court do with this? All right, this is amazing, amazing. But this is why I love family law essays. It's not like other subjects where you're right or you're wrong. You really do get to just rabble dabble, the court would consider this, the court would consider that. 90 hours a week, how is he going to raise the kid? Well, she's living in a small 1-bedroom apartment. I would say give the kid up to charity, give him up to Count Olaf or whatever. No, I don't know. Yes, the 50-50 is a good place to start. I like that, Omar. They should probably, try to have a parenting, they should create a parenting plan, which divides responsibility up. Ideally, they would look to have shared responsibility and split time between both parents. Here, there's circumstances that would necessitate spending the weekends with, probably works Bob with the weekends and Amy during the week. That seems kind of logical to me. I assume some facts right there, but I'm like, this guy's working 90-hour weeks. He's probably not working weekend. I don't know, but like maybe he could take weekends off. Kids live with him on the weekend, Amy during the week, la-di-da-di-da. As long as you mention best interest of the child, then exactly, BIC. I love that. So equitable distribution. So we did the M was modification. We did the J was jurisdiction. We did the V was venue. Now we did the P, the parenting plan. Now we'll do E, equitable distribution. So equitable distribution, marital property is split in half. Anything gotten in the marriage. So it includes appreciation of property gotten outside of marriage up to where the dissolution happens, right? I've took California exam. I had to memorize community property. Who cares? This is Florida. You have to memorize marital property. Like it is what it is. I'm speaking to you, Barbara. I know you live in a community property state. Well, welcome to Florida. Marital property. Doesn't matter. Which one do I think is better? I don't know. I've never been married. I don't plan on getting divorced. Well, I don't know. We'll see. I mean, I certainly don't plan on it. I certainly don't plan on it. I don't know what I'm saying. Someone commented on my YouTube video that I'm so woke. And I don't know if I'm supposed to take that as a compliment or an insult. I don't know what that even means. Like, I'm definitely awake. All right. So marital property is split in half. Anything gotten in the marriage includes appreciation marriage gotten outside marriage. Basically, it just means that we are a marital community. And when me and, it's interesting that Jesse was here because I actually referred him a case and I got to kind of look from the outside in about how it went down. And basically, my friend's friend, they were women, and then the man, was the breadwinner. And the whole thing was about Jesse representing the woman and trying to secure her interests. And it's interesting because like the thing that came up was his retirement funds. Does anyone know if the spouse has a claim to a pension, let's say, or a retirement plan?
It depends how much she helped. Like how much she helped put it, like for him to be able to work.
So people saying yes. What did you assume when you said yes? Because there's an assumption you must have made.
The assumption is after they got married, anything that has increased in the pension plan will be part of the marital property.
Yes, the assumption that I'm assuming y'all made is that it was a long marriage, right? If you're married for a good 20 years, yeah, you're getting that pension plan. Like that's in the bag. If you're only married for like 2 years, at best you'll get a small sliver of it. But like, yeah, if you're a loving, doting husband or wife for 30 years, you got to understand the concept and the premise of marital property and marital, just like marital property. I'm stuttering a little bit today. I think it's the heat is getting to me. So the concept of marital property is that we are a unit. We're a team. Like me and my girl against the world, whatever we get together. And we understand that, yeah, I'm at work, grinding the grindstone, and my wife is at home taking care of the kid. I mean, I'm not trying to say like, I don't want to sound too woke or asleep. I don't know what I'm saying here, but like in this situation, my wife is at home taking care of the kids, doing all this thing, which enables me to work these 90-hour weeks and get this money. Therefore, everything we have is in one pot, That's kind of what marriage means. I guess I have a very I don't want to say cynical view of marriage, but I just have a legal view of marriage. Like to me, that's what marriage means. It means that you are creating a marital property bond with someone and you're throwing everything into this pot together for the duration of your marriage. Now, there's obviously non-marital property, which are things gotten before the marriage and not mingled, and things gifted or inherited and not mingled, right? So that's a thing. If you're specifically inherit something during a marriage, that's going to be non-marital property. Me right now, I own my house right now. If I were to marry someone, that would be non-marital property because I had it before we got married, right? Like those are just things. But then if we get another house, that would be marital property. There's, some thoughts if you have marital property, but one of the spouses is using the account to have a affair and spend it badly, then, the other partner wouldn't be liable for like their gambling debts or things of that nature that they use on the marital property. Like there are some exceptions to like everything during the marriage is marital property, but the general understanding is that we're a unit. Everything we get together, except for things I had before we got married and things that are specifically devised to me, or if we literally make an agreement. Oh man, I'm gonna drop a word on y'all. A transmutation agreement, which would mean like we agree that it's not gonna be. What are you saying? Community property state?
Like in California, I know family law would be like, basically everything you're saying that they used to say it's a community property state. So I just want to know like what you're referring to. Is that the phrase we would use?
No, marital property, not community property.
Okay.
Marital. It's very similar but different, right? Just know that Florida is a marital property state, not a community property state, where everything is split in half. If at a divorce, right? If there's a divorce, the property is split 50-50 and you're just splitting up into marital and non-marital property. Don't say community and non-community property. Take that word completely out of your head. Just use marital property. So everything acquired during the marriage is marital property. Non-marital property includes things gotten before the marriage and not mingled, things gifted or inherited and not mingled. And then a marital interest in non-marital property. Like, I don't know what Will even means by that, to be honest. Okay. So equitable distribution, let's take a step back. Again, I don't want to confuse anyone here. We have modification. It needs to be a substantial material change. We have jurisdiction. The big thing is it's about where you've lived for the past 6 months. It's probably going to come down to Florida. But remember, they have to have PJ and SMJ. Venue, where the, where the breach occurred, or where they would have PJ over the parties, where any of them lives. The P is going to be the parenting plan, and the parenting plan is going to be created in the best interest of the children and try to honor our constitutional right to raise our children. And then the E is equitable distribution. And how is property divided in Florida? Florida is a marital property state, which means that anything acquired during the marriage is marital property, and anything acquired before the marriage or specifically inherited is non-marital property, and marital property will be split up 50-50. So here, Amy and Bob got married when they were 24. They're now getting divorced. Their notable assets include $50,000, a house, and 2 cars. Bob also had a number of bonds that his aunt gave him when he was 20. A week before their divorce was filed, Amy's aunt died and left her $20,000. Knowing the divorce was imminent, Amy only deposited $5,000 in their joint checking account. Who gets what? Okay, so they have $50,000, a house, and 2 cars. And the bonds as aunt gave him 20. So we can look at that one first. The bonds that he got when he was 20, right, are not going to be marital property because they were, Bob got them before the marriage was created, before the marriage existed. Okay. So a week before the divorce was filed, Amy's aunt died and left her $20,000. So that was a specific bequest, right? So knowing it was imminent, she only deposited 15 in their joint checking account. So the commingling of 5 is going to be in their joint checking account. That's marital property. But I agree with what Amy's saying. The 15 that was part of the specific inheritance would be non-marital property. Then we'll talk about the house. The house, of course, in Florida, we're going to have a whole discussion. You see the word house, you got to talk about the homestead exemption and all these different things that may be implicated. But here, a divorce, we'll just split that up 50-50. The assumption is they got the house together. 2 cars, split them up 50-50. I think that's it, right? Split the 50. Yeah, split the. I mean, ideally, without any other facts, we'll split the 55,000 up 50-50. We'll split the house up 50-50. We'll split the 2 cars up 50-50. Amy will keep the 15,000 and Bob will keep the bonds. The 15,000, the bonds will be known as non-marital property. Everything else will be known as marital property and it will get split up 50-50. Easy, right? That's what's going to happen when we do equitable distribution. The issue is how will the estate be divided? The rule is that Florida is a marital property state. Property that's considered marital property is divided 50-50, where non-marital property is kept by the spouse who is entitled to the non-marital property. Here, this is not right. It's very, very easy IRAC, extremely easy IRAC. Do not complicate family law. There's other issues we could complicate. All right, alimony based on need and ability to pay. This thing is amazing. When you're crossing out permanent, it's going to be as simple as me pressing delete, delete, delete like 7 times. And that's it. We've adjusted to the new statute without losing too much sleep. One of my students today told me that they've been diagnosed with the fear of sleeping. And I was like, great, you can spend that time studying. All right, based on need and ability to pay. So types are temporary, course of dissolution, right? During the dissolution of the marriage, you're gonna have temporary alimony. That's just gonna be like, you know, just like momentary, you're gonna get some money while we figure this stuff out. Rehabilitative, so it's gonna help you become independent, you know, like until you got 3 years to finish nursing school and become a nurse, and we'll help you with that, but then you're on your own. Bridge the gap, you know, from one life stage to the next. Yeah, I guess I like that definition. And then durational is term based on the marriage. So we've seen that we have eliminated permanent alimony. It's always going to be durational, totally dependent on what's considered long or short. Remember, moderate is now 10 to 20. Anything less is short. Anything past that would be considered lengthy. And that's important when it comes to alimony. So they love to test this stuff, and it's easy. If you just do this JV piece, we've already got to, after Equidistribution, it's marital property state, split it up 50-50, except the non-marital property, which is anything inherited or got before the marriage. The next issue is alimony. Alimony is going to be based on need and ability to pay. The types are temporary, rehabilitative, bridge the gap, and durational. These are the definitions. 10 to 20 is moderate. This marriage was 14, therefore, la-di-da-di-da, right? Pre and post-nup requirements. So sufficient time to review and reflect, an opportunity to seek counsel, statements made during the presentation of the agreement. So prenuptial agreement has to be in writing because it's in consideration of marriage. I think that postnuptial agreements in Florida are statutorily have to be in writing as well. Okay, child support. So JV Peace. Now we're at the C. The court totals both parents' net income and finds a support amount in the statutory chart. The amount is then allocated between the parents accordingly to their respective need and ability to pay. If child spending 20% of nights with the person paying support, there must be an adjustment. Okay. At the end of the day, child support, right? It's just going to be based on their net income and what's in the best interest of the child. You can literally go back to what's in the best interest of the child. It's just about these family law essays are the one subject where you can write an English major. You know, you're just writing a good story about how this estate should be divided. All right. Let's see everything else. So attorney's fees or ability to pay and based on need. That's just escrow fees, nothing too important there. Dissolution. So Florida is a no-fault dissolution state. 2 reasons to dissolve. The marriage is irretrievably broken, can be basically for any grounds, just make the argument, or mental incompetence of 3 years or more. So that is tested. So Florida is a no-fault dissolution state, and there's 2 reasons to dissolve. Okay, so that was Will's PowerPoint. And like I said, there's a couple of things I want to go over today, just so we leave no stone unturned, but now we can move a little bit faster because we got some things out of the way. So this one was done by Letty. Letty was awesome. Oh man, I've had so many great instructors for me, gone on to bigger and better things. Okay, so introduction to family law, very few testable mini topics, often comes up with property, trust, and PR. Definitely not trust anymore, which is now a multiple choice subject. Oh, you're still seeing the old PowerPoint. I'm sorry. Thank you. My bad. Okay, so this one was made by Letty. Letty's awesome. Very few testable mini subtopics. It often comes up with property, trust, and personal responsibility, but like I said, not trust anymore. Factor heavy, so heavy numbering, like these are the factors the court will consider in awarding alimony, you know, boom, 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 boom. And what people have always said about family law is if you can't remember those factors, just kind of make them up, right? Like what's in the best interest of the child, how long they've been working, what their need, you know, just like certain things like that, that I really do believe you can get away with, but you know, we're gonna see exactly what they are. So subject matter jurisdiction, personal jurisdiction is important. It's a love story gone wrong, right? Beginning, middle, end with some equity. That's a cute way of thinking about it. Marriage, divorce, property, and kids. You can tell Letty's has a cool style of teaching. So in Florida, a couple may divorce if the marriage is irretrievably broken down or if one spouse becomes mentally incompetent. And we said it had to be for 3 years. The court may continue the proceedings for 3 months to allow for the couple to reconcile, discuss one or both elements if relevant, right? So that is true. You can get ordered to do counseling and try to fix the marriage. It's gotta be the worst. Like you just want to get divorced and you're like, sorry. I don't think it happens very often. I think it's pretty easy to get divorced in this world. All right, subject matter jurisdiction. One spouse must be a resident of Florida for 6 months before commencing an action. Look for the 6-month rule. Usually that's how you know they're testing this. Nice. Personal jurisdiction. Based on the person's physical presence in the state, property located in the state, or minimum contacts, notice of complaint is required. Sorry. How do I get this little tab to disappear? Okay, marital agreement. It's really a divorce agreement. So there's types of marital agreements. There's a prenup. The main idea, it outlines the division of property, alimony, spousal support in case of divorce or death. Where's the consideration? Marriage, right? Like that's marriage, like the promise to get married, right? It doesn't need to be in writing, like we said. Postnups also need to be in writing in statute under Florida. Parties entered into this agreement in contemplation of an ongoing viable marriage can define property division, spousal support. So you already got married and then you're like, oh, wait a minute. This might not go so smoothly. Let's get an agreement down. And then separation agreement, trouble in paradise, usually defines allocation of property, spousal support, child support, parental responsibility, and time sharing. The biggest difference between prenuptial agreements and postnuptial agreements is the date of creation. A prenuptial agreement is signed before 2 people are married, and a postnuptial agreement is signed after the marriage. In case you didn't know that, right? All right, you have a marital agreement, but is it legally valid? Wait, hold up. Validity of marital agreements. A premarital agreement is enforceable only if full disclosure of financial status of each party at the time of execution of the agreement will be closely scrutinized for good faith, undue influence, fraud, and duress. So good faith, look for one spouse trying to minimize the significance of the agreement or discourage the other spouse from seeking counsel. Fraud, look for lies and failure to disclose information. Undue influence, look for a large gap of age, education, or experience between the spouses. Look for a spouse that is ill or incapacitated. Duress, look for pressure situations, threats, and prenups given last minute. No opportunity to look at or to seek counsel, pressure the family and the wedding party. And it's gotta be voluntary. And it must be in writing and signed by the party to be charged. I see you, statute of frauds. Yeah, you guys would like Letty. She was funny. All right, equitable distribution of property. It's not 50-50 always, but it should be. A fair and equitable distribution of marital property. To do this, we take into account consideration of all circumstances. For instance, millions of factors. Again, it's not always 50-50, but hold up. What is marital property? Marital, all property acquired during the marriage, which includes active appreciation, increase in value of all non-marital property during the marriage as a result of the efforts of either spouse or contribution of marital funds or assets. Non-marital property is not property born from love, usually from before marriage. Most common example, property excluded by parties' valid agreement. I call that a transmutation agreement, or gift or inheritance. So easy, right? Equitable distribution, boom, 50, not always 50-50, but you know, we're going to have the 50-50 division of marital property, but there's factors on factors. So here's the factors to consider. The length of the marriage, 10 to 20 as of July 1st, 2023, because we're the smartest people in Florida bar exam history, is a moderate marriage. Economic circumstances of each spouse. So right now, I told you can make these factors up, but instead of doing that, let's really learn them. For equitable distribution, length of marriage, economic circumstances of each spouse, contribution of each spouse to marriage, contributions of one spouse to education or career of other spouse, interruptions to either spouse's personal career education, interest of one spouse to retain marital residence for dependent children, any factors a court finds necessary and just. Retirement or pension benefits, marital property if acquired during the marriage. look out for this one, not as obvious and often tested. So I'm glad I talked about that. And I didn't even think about it. I was just saying a personal experience, but that's what they were fighting about, was the retirement account. And I said, yeah, it's marital property if acquired during the marriage. And again, if you're married for a few years, you'll probably get a sliver of the pension plan. If you're married for 30 years, you're getting all of it. Like, he wasn't going to be able to go to work unless I made you muffins every morning, you know? All right. Professional licenses and degrees, not necessarily a property interest. For example, but I was your wife during your entire miserable 3 years in law school. I dealt with your BS, but it can affect alimony, right? So it's not going to be like you get the money for it, but maybe it can affect alimony because you can consider that factor that, you know, that's a big argument that spouses make, is like one spouse went to law school or went to business school or went to medical school, and the other spouse, you know, did the domesticated, like, you know, family raising activities. And their argument is, I sacrificed my earning potential by doing that. Therefore, I should get more money. Pretty easy argument. That's why I think Jesse has a great job. I think being a family law attorney is pretty cool. It could be worse. All right, alimony, we talked about bridge the gap, transition from married to #single life, rehabilitative, limited time period so you can get it together, permanent, usually old couples, award for the remainder of the dispensed spouse. The key is long-term, 20 years or more. Durational, typically awarded when the marriage was short of moderate duration and economic need for support. Can someone pronounce this word for me so I don't say it wrong? Pendente light? Or pendente lite? I would say it's so wrong, but I think it's pendente
Delete, yeah.
lite. All right. That's what you're rocking with? Pendente lite? Don't ask the Brazilians. Whatever way I said it, someone said I said it wrong the last time, so I can't remember which one it was. All right, pendente lite, or light, or strong. Only during the time of separation till the marriage is dissolved. Yo, here's $5 so we can get divorced, right? We call that also temporary during litigation, right? We see that word pendente when something's pending, and then lite, litigation. So write about all of them plus the factors, number them, apply only relevant factors. You know, I really did like Letty as an instructor because she was very keen on, when writing an essay, spoon feed it to the reader in terms of, like, you know, structuring, like labeling, numbering, just highlighting, bolding. Like, she was very keen on that. Like, give the reader an essay that's easy to give you points for. Okay. Yeah, no, so Barbara, yeah, permanent alimony doesn't exist anymore. So I was kind of reading that. Thank you for reminding me. I almost forgot. As of July 1st, 2023, permanent alimony doesn't exist anymore. So it's going to be durational, but still it could be for a long duration, you know? It's just, I think the thing is now, like, people are living longer. Honestly, I don't want to justify the law. I have no idea why it was passed or who passed it. All right, so let's talk about those kids. What about those kids? Shared parental responsibility, best interest of the child. Best interest of the child is the primary standard for all matters relating to parenting, time sharing, and support. Literally, if you fell asleep today and you just heard one word, it's best interest of the child. I guess that's not one word. Best interest of the child. 5 words. Best interest of the child is the most important thing about family law by far. 6 months, and then we still haven't talked about the 50-mile. Oh yeah, we're about to do that. Okay, don't worry, it's coming up. All right, so shared parental responsibility is best interest of the child. Both parents involved is the goal. Whenever possible, the court wants both parents to be involved in raising the child. There's no automatic preference for giving primary care to mother or father. A parent may forfeit the right to shared parental responsibility by engaging in conduct that injuriously affects the child's welfare or morality or morals. It is rare that a parent will have no right to share responsibility, right? They have to be a real bad boy or girl. Parenting plan. The parenting plan will describe how parents will share responsibility for daily tasks with the child. Time sharing, liberal for the non-primary caregiver, designation of who is responsible for healthcare, school-related marriage, etc. Methods that parents will use with the child. Like, literally, when you get one of these, and I love how Letty put it, a love story gone wrong, you really want to go in there and be like, all right, this is what they're going to do. They're going to start by, you know, having a divorce. It's irretrievably broken. And then we're going to have a parenting plan. This is going to be said in the parenting plan. Then, you know, they have to have jurisdiction. There has to be venue. There has to be a consideration of equidistribution, a consideration of alimony. We got to talk about maybe if there's a modification, maybe whatever it might be. Just make sure you get all these points on your paper and say the word best interest of the child over and over and over again. All right, don't move the kids. I'm happy we talked about this. They love testing this. Relocating, removing a child from the state. UCC JEA jurisdiction up to 49 miles from the original house. So no need for permission from the court or the other parent, right? You can move your kid up to 49 miles without petitioning to the court, even if under 49 miles, which means outside the state, right? You can move from Florida to Georgia if it's just across the coast, or not the coast, the border. More than 50 miles, written consent of every party entitled to a time sharing is required, or serve a petition to relocate of every person entitled to time sharing. The petition must include details about the move, date, location, reason, and it must include proposed revised plan for time sharing and transportation. There's no presumption in favor or against the relocation. The standard is the best interest of the child, even if time sharing will be substantially affected. The goal is to always have those faces smiling. So just remember, 6 months for jurisdiction, 49 miles. I would get confused. You want to remember 50 or 49, whatever. It's just if you're 49 miles, up to 49 miles, you can move them without having to petition or get written consent from the other parties. So success is no accident. It's hard work, perseverance, learning, studying, sacrifice, and most of all, love what you're doing and are learning to do. Cool. There's just a couple other things, I just wanted to go over and then we'll call it a night. I really hope we get a family law essay because I think it's super easy to crush. I really believe that. So just quickly, these rules. Florida is a no-fault divorce state. Marriage is irretrievably broken. Florida can order counseling or attempt to reconcile. It can go for up to 3 months or other actions in the best interest of the child. Jurisdiction: to hear a family-related dispute, the court must have subject matter jurisdiction and personal jurisdiction of the parties. SMJ: Florida law requires at least one spouse to be a resident of the state for 6 months before commencing a matrimonial action. Personal jurisdiction: proceedings may be brought against an out-of-state resident. Personal jurisdiction against the persons may be obtained based on the person's physical presence in the state, property located in the state, or minimum contacts. Florida has enacted the UCC JEA. It prevents jurisdictional disputes with courts in other states on matters of child custody and visitation. The UCC JEA requires that the court possess subject matter jurisdiction. The Uniform Child Custody Jurisdiction Act. Does anyone know what that stands for? So you can write in the chat. I forget what the E stands for. Luis is praying for family law.
Enforcement.
Enforcement. All right, that's what I was gonna guess. Luis saying praying for family law and ethics. I just realized Rosie's like, you're gonna get ethics. I can guarantee that. 100% guaranteed you're gonna get ethics. So your prayer will be at least half answered. Okay. And yeah, Hannah, see. Initial custody determination, home state jurisdiction. A court has subject matter jurisdiction to preside over custody hearings and either enter or modify custody or visitation orders if the state is the child's home state for a period of 6 months since birth, was a child's home state in the past 6 months, or the child's absent from the state, but one of the parents or guardians continues to live in the state, right? It's very not easy, but on the test, we're getting this thing in Florida, I'm telling you. Equidistribution, so equality not necessarily means 50-50, only marital assets are subject to division, right? Non-marital assets acquired before the marriage by each individual spouse, assets gifted or devised to an individual spouse during the marriage. Marital assets, anything acquired by any spouse during the marriage, unless it was gifted or devised by an individual spouse by a third party. Appreciation and value of non-marital assets as a result of the efforts of the other spouse, the expenditure of marital funds, inter-spouse gifts during the marriage, any retirement assets during the marriage, acquired during the marriage. There's always a huge argument about whether the wedding ring is like, whatever, the wedding ring. But at the end of the day, the wife always keeps the wedding ring. That's what I learned. Okay, factors considered by courts when dividing property. Contribution to the marriage, contribution to care and education of children, services of homemaker, economic circumstances, duration of marriage, short, medium, or long, career and educational sacrifices, desirability of retaining assets free from hostile interferences from other spouses. Okay, cool. Rule number 4, alimony is available to either spouse, husband or wife. Standard, the need versus the ability to pay. Alimony should not cause the payer to have less net income than the payee. Does anyone know who got money from Kanye and Kim? I wonder. Okay, nobody's listening to me. All right. Alimony factor, sad fret me. This is cool. Sad fret me. So Kim got money from Kanye. Oh, they had a prenup. Smart. All right. So alimony factor, sad fret me. I like this. Standard of living during the marriage, age, emotional and physical conditions of both parties, duration of marriage, financial resources and sources of income, responsibilities for my own child, earning capacities, tax treatment, marital contribution to the marriage and education of children, equity, professional and academic sacrifices. There's two schools of thought here. One school of thought is I'm not going to memorize these at all. I'm just going to kind of BS my way through it on test day because it seems kind of obvious. The other one is I'm going to memorize this exact sad fret me, drop it on test day and get maximum points, right? It's just at this point, it's like, how much stuff can you cram into your brain? If that's something you can cram into your brain, cram it on in there. But at the same time, just know that family law, there is a little bit of leeway to think your way logically through it and just know that you're going to have to list factors, right? Don't just say, therefore H is entitled to alimony. Say the factors the court will consider are sad fret me, therefore H is likely entitled to alimony. So pendent lite, during the lawsuit, temporary alimony or suit money, right? We call that temporary pendent lite, suit money, covers the immediate living expenses and costs during the pendency of the dissolution, always available if there's a need by one spouse and ability to pay by the other. Bridge the gap, transition from married to hashtag single life, to assist one spouse in the transition from being married to being single. For example, 2 homes, 2 beds, 2 sets of dishes. Yeah, that's a really crazy transition, having to go from 2 sets of dishes to 1. And then max duration, 2 years, could be less, right? For bridge the gap. Rehabilitation or rehabilitative alimony, to assist one spouse in obtaining education or training necessary to become self-sufficient, need a specific plan, or it can be changed if change in circumstances, non-compliance with the rehabilitative plan, or completion of the rehabilitative plan. Then durational alimony, economic assistance for a set period of time, awarded when permanent alimony is not appropriate. The duration of alimony cannot exceed the duration of the marriage. That's probably why they changed it. So now the duration of the alimony cannot exceed the duration of the marriage. I guess that was their main thought, that this permanent alimony was lasting too long. The amount can change if there's substantial change in circumstances. Length, duration cannot change unless there are exceptional circumstances. We said now there's no longer permanent alimony in Florida. Hashtag July 1st, 2023. All right. Shared parental responsibility, best interest of the child. Best interest of the child is the primary standard for all matters relating to parenting, time sharing, and support. Factors that the courts consider when determining time sharing: parents' ability to provide a stable home environment, the child's preference, depends on the age. 7 to 8 is a good age to ask care, right? They are going to literally ask the kid, like, do you want to live with mommy or daddy? You know, that's a really good indicator. And if he's like, I don't want to live with daddy, daddy touches me, like, that's a really good indicator not to live with daddy. Parents' willingness to allow and facilitate time sharing. So when both parents are involved, whenever possible, the court wants both parents to be involved in raising the child. There's no automatic preference for giving primary care to a mother or father. A parent may forfeit the right to share parental responsibility by doing really bad stuff. Conduct that injuriously affects a child's welfare and morals. It is rare that a parent will have no right to shared responsibility. As I said, sometimes they like literally will be like, this is a con law essay. And then you'll read them like, nah, that's a family law essay. And then I've deduced that it's because the alignment between con law and family laws, you do have a constitutional right to raise your children. Parenting plan. The parenting plan will describe how parents will share responsibility for daily tasks with the child. Time sharing is liberal for the non-primary caregiver. Designation of who will be responsible for healthcare, school-related matters, etc., and the methods a child will use. Okay. Relocating, removing a child from the state. The UCCJEA, the Uniform Child Custody Jurisdiction Enforcement Act, up to the 49-mile rule from the original home. No need for permission from the court or the other parent, but more than 50 miles with written consent of every person entitled to a time sharing is required, or serve a petition to relocate on every person entitled to time sharing. Petition must include the details of the move, date, location, must include a proposed revised plan for time sharing transportation. No presumption of favor or against the relocation that standards the best interest of the child, even if this time sharing will be substantially affected. So if a court believes that there's a risk one parent will move a child from the state, the court can impose restrictions of travel, require written permission of both parents to remove the child from the state, require a parent to surrender the child's passport, or require a party to post a bond or other security. We talked about prenups and postnups. They're generally valid. They're not automatically statute to the subject of fraud, but like we said, prenups because they're in consideration of marriage, and then postnups, if they consider land or anything else. But I was understanding that postnups are supposed to be in writing in Florida anyway, so I think we can assume that. Is it agreement valid? Look for good faith, fraud, undue influence, and duress. Rule number 9. Issues of paternity. Courts may order genetic testing of the child, biological mother, and the possible fathers in order to determine paternity. Florida presumes paternity when the test results reveal a statistical probability of 95%. You are the father. Adoption, the legal effect of adoption. The adoptive parents possess all rights and responsibilities of biological parents. Adoptive child has all the rights and responsibilities of the adopted child. Birth parents do not have visitation rights with the adopted child, right? Like in a true adoption, it totally severs not only your visitation rights, but also your inheritance rights from the adopted child. So I think these laws are really good. This is all the essays are in here. We have the questionnaire, and just see what kind of questions it is. I bet they're super, super easy. If anyone can help me out here, you guys can write in the chat if I get stuck. What type of divorce state is Florida? No fault divorce. What is necessary for a court to have SMJ over divorce in Florida?
6 months.
Yeah, exactly. Thank you. That's 6 months since they were living there or whatever. What is necessary for to have PJ over divorce in Florida? Just minimum contacts or something of that nature. How is marital property divided in Florida? We're going to be a marital property state, so the marital property will be divided equally. Non-marital property will be retained by the individual. What factors determine alimony in Florida? Is this where we had like the sad fret me, like standard of living, academics, duration, all these super, super factors? Just remember sad fret me. What are the different types of alimony in Florida? Well, we talked about there's bridge the gap, hashtags that's going from married to hashtag single. There's the temporary or pendente lite, which is like during litigation. There's rehabilitative, which is trying to get her into nursing school, through nursing school. And then there's durational, which now is the longest form because permanent has been abolished. 10 to 20 is moderate. What factors are considered in time-sharing agreement in Florida? Mostly the best interest of the child, to be honest. What is included in the parenting plan, like the time-sharing, what visitation will be like, what roles and responsibility, just what things are going to go down. What's necessary to relocate a child after divorce? Nothing if it's 49 miles. After that, you either need written consent or you have to petition and serve everyone involved. What are the elements of a prenup agreement in Florida? It's got to be signed, written, not undue influence, duress, fraud, anything like that. Postnup, very similar, it's just all got to be in good faith, and you can't, we should get in writing, especially if there's land or anything like that involved. How do you determine paternity in Florida? 95%. What's the legal effect of adoption in Florida? You're like biological. What else can you tell me about family law issues in Florida? That is going to be a really easy essay if we encounter it. And that's all there is to know about that, right? Look, all I say is if you can just go through my questionnaires cold and really recite them, you're going to crush these essays. Family law really comes down to just all remember 6 months and the 49-50 mile rule. Like that's pretty much it. And then I do like that, JV Peace with a side of mustard, talking about jurisdiction, venue, parenting plan, equidistribution, alimony, child support, esquire fees, dissolution of marriage, and then modification. And we now remember that modification is if there's a substantial material change in circumstances. Anything else in this drive? I mean, the only other thing I have in here is just one essay that we saw is like, what's here. They talked about PJ, this is from 2013. In order for a party to file this, they have to be living there for 6 months. In order for them to have PJ, it's got to be a resident. They must have basis for it pursuant to long arm statute, minimum contacts, for instance. They dropped the Uniform Child Custody Jurisdiction Enforcement Acts, flexing their knowledge of acronyms. The state that issued the first order regarding the child will always have continuing jurisdiction to modify it. However, jurisdiction can also be established in the state where the child and at last one parent have resided for the last 6 months. So that's true. The state that ordered, like if there's a final judgment, the state that ordered the final judgment is the one that has jurisdiction to modify it, but also it could be established where they lived for the last 6 months. If it cannot be established, Florida could still take if no other state wanted to take jurisdiction. I told you at the end of the day, Florida's taking. Modification. In Florida, the court enters what's called a parenting plan in order to address every detail regarding time sharing. This parenting plan includes that each parent was the time each parent will spend with the child, the extracurriculars they'll do, travel arrangements, who makes decisions, whether those should be shared, and anything else. The parenting plan is normally referred to in the parents' marital settlement agreement where there's a divorce and is therefore incorporated into the final judgment, right? So there's a marital settlement agreement that's incorporated into the final judgment. The final judgment is like the final judgment. In order to state a proper claim for modification of time sharing, the party seeking the modification must allege a substantial change in circumstances that is permanent, voluntary, and material. The best interest of the child always govern. Although Florida statutes provide a lengthy list of factors that are considered when analyzing the best interest of the child, the usual factors that are mostly used by the court are continuity for the child, how likely the other parent is to encourage and foster a meaningful relationship with the other parent, the child's preference, which is weighed heavily when the child is still a minor, but older and able to express himself regarding his wants and needs, the ability of each parent to care for the child, and any past history of substance abuse or any type of abuse. And then modification of a shared parental responsibility. In Florida, when there are 3 types of parental responsibility, shared parental responsibilities when both parties are charged with equal decision-making. Anything related to children, la-di-da-di-da, is jointly shared. This is the norm, as both parents have a constitutional right in Florida to participate in the upbringing of their child and the joy of child rearing. That's a beautiful statement. I'm going to read it again. Both parents have a constitutional right in Florida to participate in the upbringing of their children and in the joy of child rearing. Ask my parents about the joy of child rearing. Sole parental responsibility is given to only one parent when it's found that the other parent is a detriment to the children or is otherwise unfit and unable to provide care for them. This vests all of the power of decision-making of the children in one parent. There's also parallel shared responsibility, parallel shared parental responsibility, where responsibility is split, but according to subject. We also called this, what did Will call it? Does anyone remember? Does anyone remember parallel or shared responsibility is also called, I think it begins with the I. No one's paying attention fast today? Nah, the word I use, or maybe a D. Ultimate. Parallel is also called ultimate. Okay, just the more you know. For example, if one parent's a doctor, blah, 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 we know that parallel, ultimate, daddy doctor, mommy school, got it. Okay, this gives the parents responsibility, but according to topic and subject. The standard for determining the best interest of child is described above. The person seeking the modification has to allege a substantial change in circumstances as well as other factors that would render the parent unfit and detrimental to the child. In Florida, both parents are obligated to contribute to the support of their children, regardless of whether they're married, separated, divorced, or never married at all. Child support is primarily based on need and ability to pay. The court will look at the respective income of both parties, the health insurance that is being paid for the child, the necessary child care costs, and the time sharing being exercised by both parents. Florida has statutory guidelines regarding what child support should be based on the parent's income. If one parent is spending more than 30% of the time with the child, then child support is calculated using a gross up method, which gives the parent with a substantial amount of time sharing a higher amount. I think that was actually supposed to be 20%. But again, this person clearly practiced family law. This is a model essay. A court can deviate only up to 5% away from the child support guidelines after considering relevant factors and with specific findings of fact that would justify the deviation. So again, remember, I write great essays. I don't really truly understand the statutory deviation chart. I've seen a colleague of mine present it and I looked at it and it looked cool, but you don't need to be an expert in this. You just know that, there's a statutory guidelines about how child support should be administered. In order to seek a modification of child support, the party seeking the modification must allege substantial change in circumstances. The change would need to be one of the factors that is used to calculate child support: income, healthcare costs, child care costs, or time sharing. The modification would date back to the filing of the petition. This means that if child support is modified to a higher amount, the difference between the established amount and the newer amount would be collectible from the other party. Okay, you could see this was someone who crushed a family law essay. I guarantee they clerked or worked for or they were a family law attorney from another state, right? But they got the key points: the 6 months, the 49-mile thing, just talking about substantial change in circumstance, material change in circumstance, talking about the different types of alimonies, the different types of different factors that go into alimony and the different factors that go into child support and all those different things. I really like that acronym, you know, JV Peace with the side of mustard: jurisdiction, venue, parenting plan, equidistribution, alimony, child support, esquire fees, dissolution, modification. I think that's solid. If we can all keep that in mind, we should do really, really well. You see here, I put a lot of, oh, this is a different folder, but oh yeah, no, in this folder, there's a lot of the essays that have been administered. I'm a huge proponent of that. Going through all the previous essays, reading the prompt, reading the model answer, and just becoming familiar with the IRACs and the way that people have gotten points in the past. But as we've said in the chat, I think people are really hoping for a family law essay. And I think that my students in particular have an opportunity to flex and show off to the graders that you know about the amendments as of July 1st, 2023, and to come full circle. The key changes that we went from 10 to 20 is now moderate. We have eliminated permanent alimony, and it no longer needs to be an unforeseeable change in circumstance. It just needs to be substantial material. So I'm glad that we had this, you know, day where, oh no, there's a brand new statute. How should we address it? Just like that, right? And that's exactly how it's going to go on test day. If you see something that's crazy, you weren't prepared for it, just know you're a river. Rivers get around rocks, right? So I really, really appreciate everyone. Probably like that. So I really appreciate everyone for being here tonight. It was an awesome class, at least for me. It was a little bit hot, but hopefully I'll be nice and cool tomorrow. I'll see everyone who's coming to my MBE class tomorrow, and I will see everyone here on Saturday for what I think is going to be the best workshop of the year, because I'm going to try and do the most.